in this very busy evening, and I try to make it straightforward and very simple. Now, before I start, I would like to express my deep gratitude to my assistant, Mr. Aiman Johari, who assists me during for the past 3 weeks. We spent together to actually finish reading this whole bunch of cases. Today, we summarize all the cases, case law, case reports, and we are going to just briefly tell you how actually the Malaysian court look at damages. Look at the issues of awarding your damages. Now, the purpose of registering your trademark is to protect you from the infringer, from using your trademark without your permissions. That is a very straightforward, simple facts. And I have, for the past many seminars, I have been emphasizing on the importance of registering, at least to register your trademarks, your brands, whether it's Malaysia or overseas. Now today, I'm going to show you some of the past 7 years of the cases that happened in Malaysia, whether it's federal court, court of appeal, or any high court cases. And we are going to look at how the court award damages, and what you expect to get from every damages, every infringement, every trademark infringement. So before this is quite, I believe this is a very useful seminar, because I've been looking around so many materials. I couldn't find any published articles, books, not even seminars conducted by anyone about assessing, damages for trademark infringement and passing off. So these seminars will give you a guideline, an idea how much you will get when you are a registered trademark owner and you're going to sue somebody for infringing your trademark. Okay. Now I will base my authorities, base my case law, case studies based on the past 7 years. So, okay, without wasting more time, I think let's jump into the slides. Wait. Okay, can you all see the slide? Just want to, if yes, just give me a raise up your hand. All right, cool. And I believe you can hear my voice loud and clear, right? Okay. Now, calculating justice. Okay, ladies and gentlemen, let's go into. First, before we move in, I would like to state my disclaimer. Okay, nothing in this video webinar shall be used in any venue. Okay, you do not rely on whatever I said here. You have to do your own investigations. Get yourself a lawyer, get someone professionals, okay, to counter check your facts. So your facts might be different than whatever I mentioned here. Okay. By the end of this course, you will learn something about how we assess damages. Okay. You will learn how the court actually calculate damages, and what are the damages you can seek from from the infringer, whether it's a total sales, loss of profits, loss of goodwill, etc., etc. So let me start with the statutory provisions. Under the new Trademark Act 2019, Section 56(3) actually spell out the remedies, the legal remedies which are available, for every registered proprietor, which includes injunction, damages, account of profits, or additional damages. So Section 56(4) provides interim injunctions besides injunction. So you see, injunction, we have two sides. One is called the interim. Interim, it means that before you complete your full trial, you will get a interlocutory. It means that interim, okay, injunctions. And the injunctions, according to 56.3, will be a permanent injunction. So 56.5, court may make order for both damages and account for profits. Okay, that's the provisions that you need to know under the Trademark Act. So 56.7, for those cases involving counterfeiting trademark. Now, the plaintiff, that means the trademark owner, may elect to seek damages and account for profits, and account for profits, and also any other additional profits. Now, for additional profits, the court can actually award additional, what they call it, damages, because it's a show of punishment to the defendant for such act of infringement. Okay. Let's start with this case. Wembley Gypsum Products, back in 2007, Court of Appeal. Now, the facts of the case is that the plaintiff is the registered owner of Pinhole, Sakura, Physio, Leopard used in the products, referred as the gypsum board, okay, GCB, okay, GCP. Now, the defendant actually is a supplier of the raw material of the gypsum board and had previously been the plaintiff supplier from 80s to 90s. Now, plaintiff claimed that the defendant continued to use and sell plaintiff trademarks products until a cease and desist letter was issued in 1994. Please take note of the date. At the conclusion of the trial, the High Court had found for the plaintiff and ordered the defendant to pay damages in the sum of 4.8 million. Okay. The defendant appealed and contended that the trial court, was wrong in assessing the damage and the award cannot be sustained. So what's the issue here? The issue here is that when they appeal for the issues here is whether the sum of 4.38 million has been correctly awarded by the trial court, by the lower court, and is inconsistent with the general object of the principal law. So what's the general objective and the principle of law here? All right. So you see, the main principle of damages in any case, okay, in any case, is that there's the provision called, if you look at the third paragraph, is to aim at restitutio in integrum. It's a Latin word. It means that the court should award such of money which will put the party who has been injured or who has suffered in the same position as he would have been in if he had not sustained the wrong. Okay, you see, the court, in any case, okay, we have a principle. The court is not here to enrich the plaintiff. The court here is to put the plaintiff back to the position as though as he or she did not suffer the damage. Okay, so if you think of making money from court litigation, you are dead wrong. Okay, yeah, you're dead wrong, because later I will show you some of the interesting cases, okay, one by one. Now, second, on the issue whether the trial court was correct in the assessment. So the trial court assessed the damage by taking into account of the plaintiff total sales and the defendant's profit margin. So in this case, the total sales undisputed is of the defendant products is actually 14.8 million, okay, 14.8 million. So the trial court actually took an average of 32.5% when you assess the total damage, okay. The 32.5% is actually the profit of the plaintiff. And so if you do your mathematics, you just multiply it by 32.5, so it will come to 4.8 million, right? So the Court of Appeal actually affirmed that the trial court assessment is correct. Okay, the way he do the mathematics is correct, 4.8 million. And plus award of 8% per annum. from 31st January 1991, the date of the first wrongful use of the trademark, to the date of realizations was also affirmed. So, so remember, like I think he stopped like during. So this is, you have to be very, very particular. Huh? When is the date when they first commence the infringement, when they first infringe, and the date when the other party has stopped. Okay, the date is very important. So from this case, we learn two things here. Number one, there's something called restitutio in integrum. That is the Latin words. It means that to restore the claimant, the plaintiff, to the original positions before wrong was committed. And of course, this principle does not allow the claimant to enrich themselves. And secondly, the burden of proof, the onus is on the claimant, that means the plaintiff, to prove the amount that had lost due to the defendant's infringement. Now, when you sue somebody for damage, always remember, you need to prove how much actually you suffer the losses. You need to be ready to prove that. The burden is on you to prove that. It's not on them. Now, failing to prove will only result that the court will award the claimant a nominal damage. Nominal damage can be 1,000 ringgit, something like that, okay? A nominal damage. So, hello? Still with me? Can you hear me? Okay, thanks. So, assessing damage for the principle to assess the damages for trademark infringement will be your damage equal to total sales, total defendant sales, not your sales, multiple by the average profit margin of the plaintiff. Okay. Now, let's come to the second most important case. Everyone in this industry, okay, in IP, when they when they sue someone to court and then they're asking for damages, they will come across this case called the Taiping Poly case. Okay, it's a company called Taiping Poly and versus Wong Fuk Tua. Okay, federal court case, federal court case. So let's look at the facts. The plaintiff is the registered owner of High Top trademark, registered in 1992 for various products such as travel luggage and school bags. Now, defendant is Wong Fuk Tua. Wong Fuk Tua, right? Trading as Gongwa Trading. Okay. Now they're selling these bags under Higer Top or Higer Top, which the plaintiff claimed confusingly similar to High Top trademarks. So plaintiff filed a lawsuit against defendant in 1996, claiming the trademark infringement and passing off. Now, the trial court found defendant liable for trademark infringement and passing off. However, during the trial court, that means the lower court, the SAR, after hearing the assessment, awarded 2.1 million, 2.1 plus million. I'm not going to read you all the figures, okay? 2.1 million to the plaintiff for the loss of the sales in the year, for the year 95, 96, plus 50,000 for loss of goodwill. The High Court on appeal reduced, okay, the High Court reduced the damage to 14,759, okay, for loss of net profit and maintain 50,000 for loss of goodwill. Why? From 2.1 million went down all the way to 14,000. Interesting, right? Okay. Now, this is what the court say. High Court judge say when they award the, reducing the awards by the learned registrar. So first, the High Court in this case apply the concept of restitutio integrum. Okay. Plaintiff also should not profit from the damages. The loss suffered by the plaintiff should be a net loss of profits only for High Top bags that it produces. Okay. Now the plaintiff should in addition be awarded the loss of goodwill. See here, the court say, now you cannot mix all the sales together. You have to be very particular. Now, how much actually you suffer the net loss by these high top bags? I'm sure like you know, there are many brands, but we are more concerned about high top bags. So the court actually, that's one of the reasons why the court actually reduced the damages amount from 2 billion over to, you know, such a low amount. So damages for goodwill, you can claim for damages for goodwill, and it doesn't need to be proven. Okay, the greater the reputation of the brand and the more value. Later we also discuss about these goodwill matters. So the court, the judge actually said that 50,000 for loss of this one, what they call it, goodwill, is okay. It's okay. Now, of course, the plaintiff not very happy, and then they appeal to the Court of Appeal. The Court of Appeal reaffirm the High Court decisions and reject the what they call it, the registrar, the loss of sales as a basis of damages. So you see, the learned senior assistant registrar, okay, he might apply the loss of sales as a basis for damages, but the Court of Appeal reaffirmed the High Court decision and say that no, that is not the way. Okay, you cannot calculate the gross sales as the basis of the damages. Okay, and opting for the net profit to be calculated. So you have to be very particular. How much net profit losses, how much losses actually you suffer? That is the most crucial point. So the Court of Appeal also upheld the 50,000 award for goodwill. So both courts no problem with the 50,000 award being the loss of goodwill. Now, of course, again, not very happy. He appealed again to the highest court, the federal court. So the federal court was faced with only one main question: whether the correct principle of law to be applied when assessing damage in a trademark infringement and passing off case is to assess the loss of sales, okay, of the plaintiff, and not by using accounting formula of the net profit after deducting tax and charging overheads, okay, or the account concept of loss of net profit. You see, one is called loss of sales, another one is called loss of net profits. So this is quite interesting. This is the issues now to be determined by the federal court. Okay, so of course, during the federal court, the plaintiff submitted that the principle of loss of sales should be applied when assessing the damages in the case of passing off an infringement. And then the plaintiff said that the concept of net profit was one of which was coined by the defendant. He said that we should look at the loss of sales instead of not loss of profit. Okay, put it this way. Okay, now on the other hand, the defendant in this case, the defendant argued that the burden was on the plaintiff to prove the damages suffered and should be limited to the loss of profit after taking into account the cost of productions and other factors. So, defendant said, no, you cannot simply just say loss of sales like that. You have to prove the damage suffered. All right. So what the court say? Court finding. The burden is upon the plaintiff to prove the loss actually sustained by the reason of the defendant's conduct. Okay, so plaintiff, you must prove the losses actually done by the defendants. Okay, cannot presume that amount of goods sold by the defendant under the infringement trademark would have been sold by plaintiff if not for the defendant unlawful use of the trademarks. Okay, now, you see, you have to be very careful when you want to claim damages. Speculative and unproven damages are also excluded. So the court will not take any speculative, anything. You cannot just like simply say, oh, because you infringe my trademarks, I suffer 20% losses from my general sales, so I claim back the 20%. No such thing. Okay, you have to prove of loss. Okay. So, damages, the court say that the damages for infringement of IP are tortious in nature. So it is something compensatory. That means that the court actually will put the plaintiff in the same old position. He would have been the wrong not committed. That means if the wrong was not committed, what is your position? So the court will put you back to the same old positions, okay? And where the claimant is in the business of manufacturing goods, so that they are in competition with the defendant, then the measure of damages will be lost profits. Okay, so very clear. The court say in this case we have to measure two things: loss of profits. Okay. Now, there's no hard and fast rules to follow. The court also say that okay. So it depends on every case, but the whole idea is that the court will not allow the claimant to be overcompensated. So see, the court here, they're not helping you guys to make money, not helping the claimant to enrich themselves. Okay. So very interestingly, the court discovered that the answer in this case is neither loss of sales or net profit. It's neither, but on the loss of business profit. New item, new word coming up here. What is a loss of business profit? Okay. So the federal court said the court was right in setting aside the award based on loss of sales given by the learned SAR. And however, the approach was taking overall net profit as submitted by the defendant also not correct. So High Court, even though he set aside the registrar SAR loss of sales, but the way he calculated the profit also not correct. Okay, that's what the federal court said. So how do we calculate what is the loss of business profit? All right. So these are the answers here. Okay. Now, counsel for plaintiff in his submission before High Court just suggests two methods in assessing loss of sales. First was before tax and all these things. No, I'm not going to say something on this. Okay. Now, assessing the loss of profit. Okay, let's jump straight to it. Now, we need a few figures before we can assess the loss of profit. First, we need the turnover. Turnover means the sales, okay? Profit before taxation. The profit margins for the infringed goods, the profit margin in general, okay? And of course, the loss of sales by the defendant side, okay? So the formula is that turnover, if you take the sales divide by the profit, you get the margin, right? Profit margin. And the profit margin, you multiply with the loss of sales, that is your loss of business profit. The loss of sales actually is not from the plaintiff side, but is covered from the defendant side, okay? Because you sell so much, this is the loss of sales for me. If I'm the plaintiff, you are the defendant, from my discovery, I learned that you have $1 million sales from there. So this is the $1 million supposed loss of sales for me, okay? So this is a loss of profits. Now, for this case, typing poly case, now, how the court actually assess? Let's look at it, all right? So we are looking at the 95 year, the 96 year. So turnover was 9.1 million. Profit before taxation, 34,000, okay? Profit margin is 0.37 if you divide 34,000 with 9.1 million. Now, the loss of sales is 1.1 million. This figure was derived from the sales of the defendant, and this is not disputed. Okay, this figure is not disputed. So both parties actually agree on this figure. So this is how you calculate. So for the year 1995, the loss of profits will be 4,312. Okay, 4,300. Please, is 0.37% multiplied by 1.1 million. So it's 4,300, sorry, not 4 million, not 4 million, okay? So looking at 96, So the turnover was 13 million. The profit was 228,000 and the margin is 1.73%. Again, we took the loss of sales during that year discovered by the defendant through the defendant loss of sales. We know that is the loss of sales belongs to the plaintiff. Then we multiply by 1.75 and then we get 17,000 ringgit Malaysia only. So 97, same formula we use. Finally, if we add up all these 3 years together, it is amounting to 32,726.70 cents. Okay, these are the loss of profits. Okay, business profit should be awarded to the so-called the plaintiff. Okay, so assessing loss of goodwill. Now, federal court agree with the Court of Appeals decisions to maintain at 50,000. There's no question on that. All right. So even though plaintiff say 50,000 is too low, and the defendant say, your goodwill only worth 10 ringgit, only worth 10 ringgit. So you see when you go to court, the plaintiff lawyer will tell you, oh, this I submitted that my 50,000 is too low, and then you only worth 10 ringgit. So the federal court saying, no, we maintain at 50,000. All right. So, okay. Now, Taiping Poly case is the birth of the, we call it the calculations of how we assess damages based on the loss of business profit. Okay. Loss of business profit. So how much this guy get at the end? I think it's 32,000 plus 50,000 and some costs for the court. Okay. The cost. Okay. So it's not much, you see, not much money. I'm not sure how much he paid for the lawyer. Okay. So now, what happened after the Taiping Poly case? So we have a few cases for the last 5 years, which I listed here. I will go through one by one. Now, some of the cases are quite interesting. And then I list down a few cases. Not 5, actually 10 cases for the past 5 years. So here we go. So the first case, 2019, High Court KL. Okay, Walmart heavy duty pump and pump matrix engineering. So this is about the this water pump hydro pump okay. So the plaintiff is a private limited trading in a pumps under this trademark called Walmart. And he filed a trademark in class 7 and 37. And the defendant is also a private company trading in pumps, water pumps, okay, hydro pumps. So the plaintiff claimed damages for loss of business profit as well as damages for loss of goodwill and reputations. Now in the discovery, we found out that the defendant has sold 7 units of the pump only. So far, they only sell 7 units of the pump. Now, based on actual sales of the pump sold by the defendant, a minimum sum of 250,000 was claimed by the plaintiff. Now, based on the plaintiff average sales price and profit margin of 7 units, okay, during this year, the loss of profit amounting to 250,000, and this is not challenged by the defendant. So these are the, in very particular the plaintiff actually lists down these 4 type of units, total 7 units, and these are the profits derived from these 7 units. Now, the plaintiff further claimed a maximum sum of 1.4 million based on the projected loss of sales between 2014 and 2015 at 20% of its annual revenue. Okay. However, the court rejected it. You see, this guy very smart. He claimed that 7 units are lost, and he claimed another 1.4 million, what they call it, projected loss sales between this year and this year. But the court just rejected it because the court say the product in issue here is specialized slurry pump, which is not a commodity that is sold daily. So the loss of business profit claimable is not from the loss of sales suffered by the plaintiff in market generally, but specifically caused by the defendant. So in this case, the defendant only sold 7 units. So your damages is only limited to the 7 units only, okay? So, but the plaintiff further claim another 300,000 for injury to goodwill. So he asked for 300,000 loss of goodwill. However, based on typing poly case and this case called alternate solution, the court assessed the damage of goodwill at 58,000. Because the 8,000, actually it's 50,000, but the 8,000 is like interest, okay? So add up to the total will be 58,000. So you know roughly, recently, the trend is like this. The goodwill damage, you only can get 50,000, okay? From this case here. Now, how this court, how Walmart comes, how in this case, how the High Court actually assess damages. First, they follow the typing poly principles. So they assess the loss of business profit. So the business profit is equivalent to the loss of sales, kali, multiply, profit margin, multiply, units sold by the defendant, okay, equal to loss of profit. So in this case, it's 250,000 only, okay? Those are the profit sold by the defendants. Now, even the defendant never challenged. The defendant said, yeah, it's true, okay, they admit, fine. But the court, again, they rejected the 1.4 million, yeah, okay? And that is something very speculative. If you put something very speculative claim to the court will throw it out, okay? So don't believe your lawyer say, I want to sue him, I can get easily 5 million or 10 million. No such thing. You have to be very particular on this, okay? So assessment of the loss of goodwill, 50,000 and 2.5% interest per year, okay? So it add up to 58,000. So you get, this guy get how much? 250 plus 58, about 300,000, okay? 308. So we come to the next case. This is very interesting, okay? I think this is this brand is quite famous, especially I think in the Malay markets or what. This Sharizat Faizal Sendian Berhad sue Faiz Rice Sendian Berhad. I heard this is a mother and son. Mother is suing the son, okay? If I'm not mistaken. Let me look at the facts of the case. Okay, first, plaintiff company is in the business of manufacture, distribution, and retail of rice under various brands. Now, the second plaintiff is the MD of the first plaintiff. The first defendant has recently commenced business of manufacture, distribution, and retail of rice under various brands. The second defendant is the MD, okay? So, both companies are in the business of distribution of rice, okay? So at the trial, the relevant subject matter is whether the defendant mark has infringed the plaintiff registered trademark. For example, Faizal Emas and Faiz Emas. Mongo Faizal Basmati versus Monga. So even the domain names, okay? Now I'm not going to go into deep into this case, the story, because I'm looking in, basically today we are just looking into how to quantify and calculate the damage. This is a very interesting case. If you got time, just have a look at it. Because I heard that this is a case that the mother actually sued the son, you know. Okay. The trial court found for the plaintiff, okay, in that case, plaintiff won, and the defendant are liable for the following 4 cause of actions: copyright infringement, trademark infringement, passing off, and unlawful interference, okay, with the first plaintiff business. Now, the defendant shall pay the following damage, okay? Compensatory damage and non-compensatory damage. So what is compensatory damage is, as I said just now, whatever you suffered, they compensate you back. Non-compensatory damages are like those, we call it exemplary damages. That means it's a sort of like additional damages to punish you so that because of your infringing act. Okay, you can seek that kind of additional damage. Okay. So in assessing the damage, both plaintiff and defendant file affidavit confirm the following persons. Okay. Now from the plaintiff side, remember the plaintiff won in this case. Now we are assessing the damage. So plaintiff represented by Injek Azhar Kasim, the sales marketing manager. Now he compute the loss of profit using typing poly formula and plaintiff own record. And on the other hand, the defendant represented by Injek Ong, accountant, expert evidence is admissible, and he gave evidence that the EBITDA, earning before interest, tax, and amortization, I think this is the common terms for accountants, should be used instead of predicted profit, okay, of the first plaintiff before tax. So to both parties, both proposed, one proposed the typing poly, the very traditional way, and the other guy proposed using EBITDA as the, what they call it, to calculate the damages. So the issue here is that, number one, whether, expert evidence by accountant is required under this Evidence Act and Rule of Court to prove loss of business suffered by the first plaintiff as compensatory damage for the full course of action. So do you need to bring in accountant, as expert witnesses for every time you want to, you want to claim damages? Okay, this is one of the issues to be answered by the court. Second, whether the court may consider expert witness regarding the EBITDA, earning before tax, interest, tax, and amortizations, okay, in assessing compensatory damages for this course of action. Now, if yes, then should the court use the average EBITDA margin or actual EBITDA margin? So first, this is very interesting. Can you use EBITDA? If yes, are you using the average EBITDA or the actual EBITDA margin? Okay, let's look at it. So High Court said we follow the principle laid down in typing poly in assessing the damages, which is using the loss of business profit. Now, the court accepted Injek Azhar computation based on the typing poly. And of course, the Injek Azhar computation is based on the first plaintiff records, and there's no evidence that the record is incorrect and unreliable. Okay, so on the issue, let's answer the first issue first. Whether expert evidence is required. Okay, now, of course, the court say the plaintiff is not required to provide an expert opinion in damage assessment. Both parties may do so, with the court deciding its relevance and weight on case-by-case basis. So court say, yeah, you can submit but I still have to consider on case-by-case basis, not an issue. Okay. So on this issue of whether the court could consider EBITDA. Now, the court accept EBITDA in applying loss of profit basis. However, the court reliance on EBITDA in this case does not mean that the plaintiff is mandatory required to adduce an accountant expert opinion regarding EBITDA to prove damages. Okay, again, in this case, the court, yes, I accept the EBITDA when you calculate the loss of profit, but not necessary and not compulsory that every time you need to prove EBITDA when you want to prove damages. Okay, this is what the court say. Referring back to the typing poly case, remember, there's no hard and fast rule as to how the court may assess damages. So then, since the court accepted EBITDA, should the court accept the average EBITDA margin or actual EBITDA margin? Okay, so here they said that the average EBITDA margin was 3.66% was used instead of the actual margin of 2.06. So the court rejected Mr. Ong expert view regarding the use of actual EBITDA, because the actual EBITDA margin is caused by the infringing products. So if the defendant is allowed to use the actual EBITDA margin, this is tantamount to allow the defendant to profit from their own wrongdoing in committing the four cause of actions. Okay. So next, we come to this another court case called the alternate solutions. Again, it's a very recent case, 2019. Now, plaintiff, they are trading tobacco, and they are this owner of this trademark called Sugandhi. Now, the first defendant is an individual trading in the name of Inter Platinum Enterprise. They import tobacco from the second defendant. So second defendant is an Indian incorporated company involved in manufacturing, distributions, and sales of tobacco under Golden trademark. The plaintiff claimed that the first defendant imported counterfeit tobacco bearing Sugandhi trademark, leading to a seizure by the Ministry of Domestic Trade. You see, as I mentioned previously in my other seminar, registered trademark owner, you have the rights to lodge a complaint, official complaint with the assistant controller of the enforcement unit of the Ministry of Domestic Trade against anyone who actually counterfeit your trademarks, okay? And the enforcement officers will raid the place, will seize every counterfeiting products, okay? So when they seize the product, they will put in their store. Now, here, plaintiff filed the suit for trademark infringement and passing off. The defendant counterclaimed, seeking to expunge the Sugandhi trademark and alleged that plaintiff passed off their Golden trademark. Oh, trial court dismissed the plaintiff claim and upheld the defendant's counterclaim. Okay, damages for passing off Golden trademark were assessed. So here in this case, the deputy registrar awarded special damages amounting to 118,000 and damages for the loss of goodwill amounting to 150,000. So a total of 268,000 to the defendant, okay? Of course, the plaintiff was not happy and filed to the current appeal, okay? So let's look at the assessment. On special damages, the 118,000 for special damages comprising of two subheads. The cost of perishable imported tobacco that become worthless due to the seizure and prolonged detention, therefore is amounting to 95,000. And this is called demurrage charges. I think it's called logistic lah, something like that, warehousing and logistic, okay? Amount of 22,000 for storing the detained imported tobacco in the warehouse. So the defendant has failed to establish what and how much the imported tobacco products precisely seized and detained. And the evidence to prove the existence of imported tobacco products such as a bill of lading were not produced again by the defendant with explanation as to why they were non-existent. Okay, so when you come to this claim, court asks, wait, where's your bill of lading? The defendant don't even produce that. Okay, so how you expect the court to compensate you? So defendant also failed to prove the demurrage charges leading to this seized and detained tobacco products. Therefore, this whole special damages is set aside. Okay, it's set aside. Now on the loss of goodwill, they follow the typing poly case. The court is the view that 150,000 awarded by the deputy registrar is too much and without good explanation. And the court actually assessed the damages of goodwill amounting to 58,000 after taking into account inflation of 7 years, that means there's interest, average 2.5% per annum. So they reduced from 150,000 to 58,000 on loss of goodwill. So again, I come back to this special damage. So what happened, like in this case, is that the court actually set aside the whole special damage. I think they only award a nominal damage of a very low price, okay, low cost, okay, to the what they call it, to the defendant, because you simply cannot prove anything. All right. So again, this story is to tell you that you need to be prepared to show proof, okay, when you are claiming for damages. Now let's come to this another very interesting case. Hugh Chai Sing, Fertiland versus Medtronic, this company, okay, 2019. This is about the this Ferti trademark. Now the plaintiff Hugh Chai Sing is a importer and distributor of organic fertilizer and the registered proprietor of this trademark Ferti trademark. The defendant, they are private company involving in providing engineering solutions, including fertilizers. The plaintiff claimed that defendant infringed his Ferti trademark, committed passing off an unlawful interference with the trade by advertising infringing fertilizer in the local newspaper and Agri-Farm magazine without his permission. Okay, so this is the cause of action, okay. Now, after the trial, defendant were found liable by the High Court. Decisions of the High Court was affirmed by the Court of Appeal, and now we are talking about leave to appeal to the Federal Court was rejected. So the court case actually stopped, okay, ends at the Court of Appeal because the leave to appeal to Federal Court was rejected. Now, in consequences, the plaintiff went for assessment of damage before the Deputy Registrar, and then the plaintiff was awarded the sum of 1.6 million, 1.67 million, which break down as follow. Okay. Now, so this, you look at the white color column, okay. This is how the court actually calculated the what they call it, the damages. Okay. So they take 5 million, divide by 3, and that's how they what they call it, get the figures, right? 1.67 million. So now, when appeal, the court actually reduced. Now, initially they awarded 1.67 million. Now the court actually, when appeal, the court reduced from 1.67 to 1.1 million. Okay. So how do we come to this figure of 1.1 million? The plaintiff contended that as alternative to the loss of business profits, as were based on typing poly case, the plaintiff can also alternatively be assessed on the royalty and user rights. So this 1.1 million actually based on the royalty and user rights. The court held that the learned registrar made his assessment by averaging the amount in the heads of claims made by the plaintiff, which is wrong in principle, because the entitlement of damage for loss of profit and royalty rights are mutually exclusive in the alternative. Meaning to say that royalty rights and damages, loss of profits, these are, you know, exclusive in alternative. It means you can have this or this. Now, according to the plaintiff, the royalty rights basis of assessment is fair and appropriate here because defendant, having also suppressed material document evidence, failing to comply with the delivery up, and okay, this one not big deal lah. So let's look at this damage. From the evidence adduced by the plaintiff, which were not challenged by defendant, the plaintiff mark at the material times was available for hire with the following terms. You see, Fertiland, this is quite interesting because especially if you are dealing with licensing and franchising. Okay, so Fertiland actually offer something like licensing kind of royalties for anyone. So if you want to use the mark, you have to pay 40,000 on the signing fee, and monthly license fee is 5,000. And of course, if you would like to have a nationwide license fee, there will be 1 million for non-exclusive use, 5 million for exclusive use. Okay, so this is the royalty that the plaintiff offer. And the plaintiff also claimed for a royalty rights of 1.1 million based on signing fee plus 12 months of monthly license fee plus nationwide fees, non-exclusive. So this is one of the claim by plaintiff. And the court say that, okay, 1.1 million is fair and temperate on royalty or royalty user right basis for a year. Okay. Now the court held that, okay, plaintiff, yes, they award you 1.1 million based on these figures, okay, based on all these figures. So the court also award 58,000 for loss of goodwill and reputations. So altogether, how much you get? How much you get? 1.158750, 1.1 million, just to use the name Ferti. And then he managed to claim based on royalty usage rights of 1.1 million. Okay. So let's look at another case. Organo. Okay. Now the plaintiff Organo is a Hong Kong company and owner of this OG and Organo Gold in Malaysia. They also registered the trademark in some other country. The second plaintiff is a private company. It's a indirect owned subsidiary of the company, okay, of the first plaintiff. So the first defendant is a private company in Malaysia involving in the business of trading in mineral, iron ore, coal, and commodities. So first plaintiff licensed Norwest Industries as the sole and exclusive manufacturer for its branded pre-mixed coffee products. The Gourmet coffees are manufactured according to the label and standard to Malaysia and for sale in Malaysia only. Now, plaintiff discovered that the infringing Gourmet coffees were packed, sold, and labeled in a manner substantially as though specifically for Malaysian market. This infringing coffee, Gourmet coffee, were sent to Norwest for testing. Okay, Norwest is a what do you call it, exclusive manufacturer, okay, for these products, and they verified that the sample you sent to me, they are not genuine, not Gourmet coffees produced by them, by the plaintiff. So again, second defendant is an individual, a director and shareholder of the first defendant, and he is a formerly distributor registered with third plaintiff but was removed on the 24 November of 2015. So in assessing the damage, the plaintiff has elected to opt for an account of profit made by defendant in respect of coffees sold between 24th September 2016 till 12th March 2018. Now that estimate the same to be around 3 million. So the plaintiff also claimed damages for loss of reputation and goodwill. So in the discovery, the plaintiff based on the loss of profits, business profit, and then the defendant sales of the coffee were computed and summarized as below. So this is the figures of various Gourmet coffees they sold, okay? This is a sales amount. Now, total quantity was therefore amount to 7.5 million, and this figure is not challenged by the defendant, okay? The defendant contended their profit margin was at best 10.65 after charging overheads, while the plaintiff contended that the profit margin should have been averaged 20 to 25%. Okay, so the court actually in this case, he held that the average profit margin is 20%. Now, the court also said that, hey, last time your $1 is 4.45, and the plaintiff say, no, it should be 3.98. So the court assessed the loss of profits. So they took the average of these two currency and they multiplied by the sales amount 7.5. They come up with 6.7. And the 6.7, okay, they took the profit margin of 20%, which is 1.1 million. Okay, if you look at the bottom, this is how they accounts for the loss of damages. Okay, loss of profits. So in this case, the loss of goodwill also, they follow the typing poly case, which is 50,000 plus interest, and then total award amount that you can get is 1.181 million. Okay, so this is the total amount that damages that the plaintiff obtained. Okay. Interestingly, we have a celebrity here, and this guy is called Muhammad Hafiz. The suing Kamda Senjam Berhad. Kamda, you know, that is quite a popular departmental store. That was happened in 2023 High Court. Okay, so what happened in this case is that the plaintiff is a celebrity and he has his own brand of apparel online and boutique under his own name. So defendant sold the apparel under the name of Hafiz Hamidun, okay, and then Hafiz Hamidun, okay, after receiving the letter from plaintiff. The plaintiff in this case is Hafiz, Mr. Hafiz, okay. Hafiz brought an action for thought of passing off and claimed 5 million in damages. So the celebrity is suing Kamda for 5 million in damage, okay, and then 54,000 for loss of endorsement fee or royalty. However, the High Court disallowed the 5 million. High Court say no, 5 million too much. He claimed, and he awarded 200,000 for the plaintiff goodwill. You see, just now before many cases, you came across the loss of goodwill only 50,000, 50,000, 50,000, very miserable. And why in this case, the court suddenly award 200,000 for plaintiff goodwill and 54,000 for his loss of endorsement fee. Okay. Now, when you appeal to during appeal, the Court of Appeal allowed the 5 million. The Court of Appeal allowed the 5 million loss, what you call it, damage. Okay. However, the federal court, when they appeal again to the federal court reversed the Court of Appeal decisions and upheld the High Court 200,000 award in the damage. Federal court say no 5 million, 200,000 maximum. Okay. So what's the issue here? So whether the plaintiff is entitled for 5 million damage for his loss of goodwill, you must understand, he's a celebrity. How much is a celebrity worth when you passing off? I mean, when you passing off his goodwill and all this thing. Okay. Now, the court say it's the plaintiff's duty to establish the amount he claims is entitled. Otherwise, plaintiff must be awarded only with nominal damage. So plaintiff, you have to show me that you are entitled to such damage, or else the court will just give you a nominal miserable damage. Okay, and refer to typing poly. The defendant argued that as the plaintiff failed to prove the amount of damage as a result of passing off, the court must disallow the claim of 5 million and only entitled to nominal. The defendant further asks this court to consider a case of PJ Uniform versus St. John Ambulance. This is a very interesting case, but I won't be talking about this case today. It's a 2018 case, quite recent, where the Court of Appeal actually awarded to St. John Ambulance Malaysia a damage of 200,000 ringgit, despite having wrongfully, the plaintiff having wrongfully used the mark for 30 years. Okay, this guy, PJ Uniform, wrongfully used St. John Ambulance mark. Maybe he's selling some uniform, okay, without, and he sells St. John Ambulance logo, using his logo, whatever. without his approval for 30 years. 30 years, 3-0. At the end, the Court of Appeal only award 200,000. So 30 years, how much money you can make? We don't know. So come back to this issue of 5 million. Referring to typing poly, in regard to loss of goodwill, the court resolved that when dealing with celebrities, in this case, when dealing with celebrities, determination of the appropriate quantum of damages must correspond with the status and stature of the celebrities, okay, which could be garnered from his personal achievement and fan base. So we have to see how famous you are. Now, the court also refer a few cases outside of Malaysia. For example, this Eddie Ivan, a prominent F1 race car driver, was only paid a British pound 25,000 in damages. And this Rihanna, a popular singer, sued for 3.3 for unconsented sales of shirts with her photograph. So someone actually print her photograph on the shirts and then sold it. And the court did not order for damage in that case. She sued for 3.3 million, but the court did not order for the damage, but ordered Topshop to pay 1 million pounds for her legal costs. That's all. Okay. And these are very popular kind of celebrities. So what about him? Let's come back to him. The court has considered the evidence provided by the plaintiff to demonstrate his stature as an accomplished singer and widely renowned celebrities. Okay. Now, of course, the court said the plaintiff cannot claim his standing as a Malaysian celebrity to be at par with Datuk Sri Siti Nurhaliza. Okay, but the court also took judicial notice that there's no conclusive method to determine a celebrity popularity. All right. So, but one of the things that the court actually noticed is that the celebrities' social media, their followers. Okay, and in this case, the plaintiff have 1.1 million followers on his Instagram. So the court is conscious of the facts and in deciding this damage of the award. So at the end, the court found that a sum of 200,000 as an award for damage to the plaintiff goodwill as a reasonable and just amount for 72 days period. So I'm using this, your name or something like that for 72 days from 31st January until April. So I think it's a fair amount. Okay, 200,000. Not many people can make 200,000 in these few days, right? Okay, so let's move on. PLK, what time now? Okay, I might want to jump a few cases because some of the cases are quite similar. But PLK, let's look at PLK first. This is quite interesting. I think manufacturer, you should take note of this case. PLK versus Swasta Damai. Okay. Now the plaintiff in this case, they want to claim a sum of 121,000 as special damage and loss of business profit of 1.9 million. The plaintiff initially, they manufacture a product known as PLK LV100. Okay, on the top of these what they call it, the graphics, the image I shown on the top, which replaced the old products called PLK 100CO. Now, because the defendant market the counterfeit products which were similar to PLK LV100, the plaintiff has decided to discontinue the PLK LV100 and revert back to the old product, the PLK 100. So in this case, the plaintiff incurred 121,000 loss for re-establishing the manufacturing line for the old product of the PLK 100. Okay, and now the plaintiff claimed 1.9 million being estimated profit from each unit of PLK 100 and PLK 100, the old products, for average annual sales and profit for the 5 years period from June 2017 to May 2022. The plaintiff said the loss of business profit was the differential sum from what it would have earned if he would to sell this new product for the past 5 years. So basically, you come up with this figure based on the number of units of you selling the old products, okay? This old product, PLK 100, CO, and you say that I would make this money if I were to sell the new products, okay? You know, the base, okay? You understand? So, decisions, High Court, accepted the plaintiff claim of 121,000 as special damages because it is reasonable to revert back to production because you have to re-establish your production line for PLK 100 CO, the old one, okay, the old products. But the court unable to agree with this 1.9 million as the loss of business profit because the plaintiff alleged that the sum of the profit it would have made from selling PLK 100 had it sold the same number of PLK LV 100 as it did with these old products. You know what I mean that? You know what I mean, okay? That means that, hey, I could have made this much of money based on the number of units I sold with the old product. Meaning that I could have sold, let's say you got 100, you sold 100 units, I could have sold another 100 units of the new products, and I'm counting the loss of business profit from it, okay? Now, the court held that the Taiping Poly principle of loss profit basis do not extend to this scenario where the plaintiff had elected to sell an alternative, cheaper product and still desire to claim the profits it would have made from selling the original but the most expensive products. So the court say that, hey, you sell this, you cannot compare, you sell these cheaper products and you want to claim the profit of the more expensive products, okay? So in this case, plaintiff asking for 1.9 million, right? Loss of profit. So the court only award a nominal damage of 1,000 ringgit sahaja. And then the court ordered the defendant to pay 80,000 solicitor fee and 2,100 translator fee. So you see, this is the fees, total damage. Okay, so for punitive additional damage. Punitive means to punish that fellow, okay? The plaintiff claimed 1 million ringgit Malaysia for the following reason. Plaintiff had strong reputations since 1976, according to them, and they are TMB designated supplier. PLK mark has been valued by experts at 2.2 million. And it had received complaint from customer that tarnished the plaintiff reputation. And defendants sold the counterfeit product at lower value, 23 ringgit against 48 ringgit, which would affect the business, okay, plaintiff business. So in this case, the court awarded 500,000. We call it exemplary damages to the plaintiff. Okay, still better than nothing lah. So in summary, how much he get? Okay, he get 121,000, 1,000 for the loss of profit, 82,000 for the cost, lawyer cost, 500,000 for the exemplary damages, and 10,000. Okay, all these damages, PLK, the plaintiff got it from the court. Okay, so do I have time? I think I would jump to the I would jump a few cases. Okay, I would discuss these two cases. Now let's interesting. Last case, Huawei. Okay, Huawei Su Oi Sun Lai. Okay, this is quite a recent case, 2024, last year case. Now, simple of the facts. The plaintiff is a well-known company, you know lah. okay, in communication technology and smart devices, okay. Plaintiff also manufacture, distribute, sell accessory used with his smart devices like Bluetooth, cables, headphone, etc., etc. Defendant is the sole proprietor, okay, known as the OSH Gazette Wholesale Enterprise, and this is maybe a sole proprietor, okay. Now, in April 2023, a raid by the authorities on defendant business premise resulted in a number of counterfeit accessory bearing the plaintiff trademark being seized, including counterfeit Bluetooth, earbuds, cable, headphone, adapters, and plastic bags. So, you know, it's so difficult to do business. Enforcement came, sapu everything. So, plaintiff is claiming what against Oi Sun Lai, the defendant? 187,000 for loss of profit, 100,000 for additional exemplary damages, 50,000 for damages for unlawful interference with trade, 30,000 for assessment of proceeding. Okay, 100. So you see, for loss of profits, the plaintiff claim is based on the following data. Okay, turnover, profit, and loss of profit, 426,000. 426 loss of sales, loss of sales. And applying the typing formula, profit over turnover multiplied by loss of sales. This is the profit margin, loss of sales, and equal to 187,000. The court distinguished typing poly formula. The facts in typing poly is that the goods which the defendant sold were the same as the primary goods that the plaintiff sold. The defendant primary goods there were in direct competition with the plaintiff primary goods. Okay, you see in the present case, the defendant, they are only selling accessory to the plaintiff main and primary products, which are telecommunication device. So Huawei, you know, like they're selling handphone, right? Smartphone or whatever. So this poor guy here, he's selling accessories to the, you know, Huawei's kind of main products. So thus, the court accepts plaintiff contentious that the defendant has sold a minimum. So the court asks, hey, plaintiff, how much that you seized from the defendants? So you say they sold a minimum of 4,684 units of counterfeit goods, for which he would have obtained a minimum value, revenue of 31,000. And therefore, this is the award for the loss of profit. Okay, the court rejected this 187,000. So pity Huawei, do all the mathematics, and then the court only said, all right, 31,000, right? Okay, this is all your so-called award for the loss of profits. Okay. So for this case, the court only award this. Now I give you a summary. Let's recap. Okay. So starting from Wembley case. Okay. Initial claim by the plaintiff is 14.8 million. Loss of profit at the end, they got the damages is 4.8 million. So you see the comparison. Okay, you can look at the chart and compare. Typing poly case, initial claim is 2.1 million, and loss of profit, the total damages awarded is 82,000. Okay, and Walmart, remember the pump, water pump. So initial claim was 1.4 million, I think, and at the end, they only got 300,000, 318,000. Faisal, Syarikat Faisal, the rice producer, initial claim about 4,200,000 of this one. So, and they almost got what they're asking for, except that the loss of goodwill, they reduced to 100,000. But the court actually gave them additional damages, exemplary damages of 100,000, and statutory damage of copyright is 60,000. So all in is what, 4.1 million. 4.1 million, okay? So Syarikat Faisal is very lucky lah. He got back what he want lah. So actually alternate solutions. So other damages disallowed. And remember in this the PLK one, the Swiss what do you call it, alternate solution, PLK one, the TMB one, they're asking for a lot of money, right? Okay, special damages, or I think how much, 1.9 million if I'm not mistaken. Yeah, they got nothing. Okay, they got nothing for the business profit. They got, I think, way less. It's a nominal damage, 100,000. Fertiland, 1.67 million, and they got 1.1 million. Okay, very good. Organo asking for 7.5 million profits, but they got 1.26. Okay, 256, sorry, 1.256 at the end. Hafiz, remember this celebrity? He asking for 5 million goodwill, 54,000 royalty, and he got 200,000 for goodwill, and then 254,000 total damages. Okay. Oh, sorry, PLK. I'm mistaken. Sorry, I'm mistaken. Alternate with PLK. PLK asking for 1.9 million profit, 121,000 special damage, and 1 million exemplary, but he got 1,000 ringgit nominal damage. Okay, 1,000 ringgit from 1.9 million, and then at the end he got 500,000 for exemplary, and total is 715,000. Okay. Now Great Food. Okay. Great Food is the one, and Portland. Okay. Lastly, Huawei. Huawei asking for 187,000 profit, 100,000 additional damages, unlawful interference. At the end, he got only 79,000. Okay, all in 79,000. So, okay, this just 1.5 hours. Just write the time for to end these sessions. And thank you so much for coming and for joining this webinar. And wait. Okay, I'm open to Q&A. If you have any questions, you can please type in the Q&A. Wait, let me just stop recording.